Hi, everyone. Harry here to talk about more good tidings from District Judge Karin Immergut in Portland. She authored the opinion that I was so interested in and buoyed by that I think provides the key to all federal courts, including the U.S. Supreme Court, for getting out of the trap of permitting Trump to exercise emergency powers based on bald-faced lies, essentially. Falsehoods, let's call them, as she does. Though she comes pretty close to calling them not in good faith, as I'll describe. But remember, she's the one who said, okay, I got to defer. Ninth Circuit has told me I've got to defer, but that doesn't mean I accept things untethered to the facts. And she also really was good in a sort of understated way, but of staking out the great stakes for democracy of this case. Okay, from her, it went up to the Ninth Circuit, where a divided panel, two Trump judges, set aside her preliminary injunction, or actually temporary restraining order, with a very sort of unpersuasive and kind of dismissive just assertion that she had substituted her own views for the facts and evidence. And that was just patently false if you looked at her very careful opinion. Thereafter, the Ninth Circuit as a whole vacated that panel opinion and set this case for en banc treatment. At the same time, of course, the Supreme Court Illinois case is working its way up. We thought that might be any minute, but now we know it won't be until sometime after November 17th because they've ordered extra briefing. Now back to Immergut. So her temporary restraining order was due to expire over the weekend, and she held a preliminary injunction hearing, so actually took evidence, considered exhibits and the like. And in order to have some time to give her preliminary injunction opinion, which is a pretty big deal. That's like district courts, part of their bread and butter is really having full-bodied opinions when it comes to entering preliminary injunctions. So she asked the parties, can we just extend the temporary restraining order that's in place for a week or so in order to deal with the preliminary injunction? And the ever courteous United States said no, they wouldn't do it. So she had to enter a new temporary restraining order, and she's done it. And that happened now, that she's done a new one that will stay in place until the end of the week. And in this opinion, she says, I will have my actual opinion on the preliminary injunction by the end of the week. And it's a big task. Okay, so first she summarizes, she heard 3 days of testimony and an argument that ended at the end of last week, 750 exhibits, trial testimony, arguments of counsel, etc. So the whole thing, and this is on basically the 10 USC 12406 assertion that is still working its way up, where she said in her temporary restraining order, the U.S. has proffered two bases. One, there's a rebellion. That's not happening. And two, the regular forces are overwhelmed. I don't think so. And even with deference. So that's the thrust of it. And now they've had the actual evidence about this. Okay. And her opinion's really strong, including in some new ways. So the United States tries to say you can't even extend the preliminary injunction. She says, tish tosh, of course I can. And of course she can. They're just so, throw it against the wall and see what sticks, which is just the opposite of what you expect. We've come to expect over years from the federal government, the United States. They give valid arguments. They are honest when the arguments don't add up. and they are sort of special counselors to the court as well as advocates. And these guys just act like, you know, anything goes defense attorneys or whatever. I'll just throw everything possible. And actually, there's a method to their madness, even though it's very kind of unbecoming or not what we've come to expect the U.S., which is they just hope that there's everything in the record for when things get to the U.S. Supreme Court, and maybe there's a throwaway argument that their friends on high will embrace. Anyway, Immergut explains that there's standing and the injury that's really happening now to the state and of Oregon, and then goes into the preliminary injunction, which is a sort of familiar inquiry of saying there's a likelihood that they'll win, which is very close to a kind of parallel path to saying, who's right, as you would do in a final entry of an injunction, and she's given every sign that she's going to do it. But when she comes to likelihood of success, she says, it explains again, got to give a great level of deference, but the court may review the determination to ensure that it reflects a colorable assessment of the facts and law within a range of honest judgment. And then here, this is a sentence that jumps off the page. The president's exercise of his authority to maintain peace must be, quote, italics, conceived in good faith in the face of the emergency and directly related to the quelling of the disorder. This is basically Immergut saying, this wasn't in good faith. It isn't in good faith. That's a breathtaking thing, or it would have been, years ago, to say of the president, especially for a district court. But, that's really just calling it straight at the level we are on, because, she goes on to explain the invocation of 12406 was likely not made. The likely there is, I'll give a final kind of thought about it when I issue my opinion. But in the face of the emergency and directly related to the quelling of the disorder or the prevention of its continuance. And she says, critically, the credible evidence at trial established that after a few days in June, where there was, more unlawful activity, the protests outside ICE between June 15th and when this suit was filed were generally uneventful, with occasional interference to federal personnel and property. And federal law enforcement, along with local enforcement, were able to manage the situation and arrest and prosecute those responsible for criminal conduct, meaning you don't number the second path to 12406, rebellion, doesn't make it, and the third path, they're just overwhelmed. Now, the administration came in with a new sort of wrinkle on the argument for 3, saying they have been ordered, has ICE, to double or some huge quota of arrests, and the hubbub and demonstrations and occasional violence distract them from that job. Man, that is a very diluted and watered down factor for unable to do their work. So, you can imagine the Supreme Court has issued orders for briefing on that factor. And if, what comes out of there is some sense of unable, well, they're distracted. Again, the law would be an ass, it seems to me, but that's their latest argument. And she says, the court concludes the president didn't have a colorable basis to invoke either of these, and specifically points to what the Ninth Circuit opinion saying minimal interference with the execution of laws is by itself insufficient to justify invoking 12406.3. So, she's really focused and clear-eyed and says she's going to do this all by Friday. All indications are that she's going to say you have no basis and enter an injunction. There's one other thing that she addresses that people haven't before, and a new, I think, argument for rejecting Trump's overall activity, which is she points to this idea, the administration is doing this in Illinois as well, of sending in Texas National Guard to join the fray, and says that's a violation of the 10th Amendment and of the principle in Shelby versus Holder, the case involving the Voting Rights Act, of treating all states as equal political entities. When the court said it's time to do away with this preclearance requirement, it stated a constitutional principle of treating all states as, of equal dignity and kind of sovereignty. And to take the Texas National Guard and send them in to Oregon is really a kind of slap in the face or an offense to Oregon in that way. That practice has really seemed problematic to me from the first we've heard of it, even though Texas is, sign me up, happy to do it. And she, I think, stakes out a pretty compelling reason why it might be. That's also a new contribution from Immergut to the ongoing debate, and could itself, in fact, wind up in the Supreme Court, because when briefs are filed by Illinois, and that's going to happen within a couple of weeks, they could adopt that argument as well. Okay, so there you have it. Immergut's really hanging tough and even expanding on what I thought was really a sort of exemplary analysis. We'll see what comes of it, but it seems to me on Friday we can expect an opinion from her entering a permanent injunction against the United States' deploy of National Guard in Portland. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.